My name's Sandy Walker. I'm a partner in the Toronto office. I practice in the area of competition law and foreign investment review. I'm also the head of the regulatory practice group in Canada. So I'm going to be speaking this morning on competition enforcement in the digital economy, and I'm joined by Margot Patterson. Can you hear me if I'm back here? Because I have this tendency. Okay. I'm joined by Margot Patterson, who's counsel in the Ottawa office of Dentons, and Margot specializes in a number of areas, including the Competition Act and other statutes relating to marketing and advertising. So the way we're going to cover it this morning is I'm going to start off giving you a bit of an overview of what competition enforcement in the digital economy, and I'm going to talk about a little bit about how the Competition Bureau is dealing with mergers, monopolistic conduct with this sort of digital lens. Margot is then going to focus in on competitive marketing. So we're going to start off with the first slide is basically a series of headlines or manufactured headlines, I have to admit. There is a lot going on. You read about it constantly in the media. Competition agencies around the world are looking at competition issues arising from the global economy. Obviously, they're looking beyond competition issues as well. For example, the Federal Trade Commission in the U.S. has created a 30-person task force to look at digital economy issues. This is after they held something like 8 months of hearings on antitrust issues arising in the digital economy. In the UK, there's the Furman report, which looked at the digital economy. In France and Germany, they did a joint paper several years ago. They are now, there have been papers by the Commission, the European Commission as well. But not only have they been studying it, at a global level, there has been enforcement against some of the tech giants. You'll have read about a $1.7 billion fine against Google in the EU in March. And there are lots of examples of this. So I think the question is, you've got this sort of big picture focus on the digital economy, including actually, and I've got the Elizabeth Warren quote where, she wants to break up the giant tech companies. But I guess, what does all this mean? What does it mean in Canada? So we're going to have a look over the next probably 20 minutes or so. What is going on in Canada? We've also had studies in Canada. We've had, there was a paper on big tech, there was a fintech paper, but there hasn't been as much enforcement activity as there has been globally. So we have part of the landscape of the picture that I'm going to talk about is we do have a new sheriff in town, and that is Matthew Boswell, who officially became competition commissioner in March of this year. He heads up the Competition Bureau, which is, as everyone I assume knows, but in case you don't, the Competition Bureau is the federal agency that monitors and enforces competition law. Mr. Boswell previously served as interim commissioner, but prior to that, he had 8 years' experience at the Ontario Securities Commission, and he has indicated that the Bureau wants to focus on the digital economy, and he has ambitions to be a world leader in that regard. he's also said he plans to more aggressively enforce the Competition Act. I take that with a bit of a grain of salt. All new commissioners, when they come in, they say they want to really enforce the Competition Act more aggressively. So I don't think it's that meaningful. He has said he is considering or is looking to use his injunctive power more frequently. So as I alluded to before, the Bureau has been looking at the digital economy for a while. So the FinTech study in 2016, it did the big data paper in 2017. In May, Minister Baines issued a letter to the commissioner asking the commissioner to look at enforcement in the digital economy. It was kind of puzzling, given that the Bureau had already been studying this, but it was part of the minister's announcement of the digital charter, so it fit in with that theme. In July, the Bureau hired a chief digital enforcement officer, and there's that officer and that position really was indicative of the Bureau's intention to use digital digital means, for example, to detect bid rigging. And the Bureau has been talking about that for a while, but now they've hired someone whose focus is solely on the detection and monitoring of marketplace conduct. The person that they hired is actually from IBM, and so he's somebody who really understands how things digital work. He is not so much he's not an expert on competition in the digital economy, but he knows about how to detect and monitor, and this will assist in the enforcement of competition law in the digital economy. So I don't know how many people here are aware of this digital call-out, and maybe I could just get a show of hands. Did people read about the call-out by the Bureau in the first week of September? Basically, one of my partners calls it a snitch line, but what the Bureau did was they issued this paper. It was 5 or 6 pages, asking people in the marketplace to comment on why certain digital markets are concentrated. Have they heard any complaint, or do they have any complaints about how the digital markets are working? And I should clarify, digital markets, I mean, the entire economy is digital. If you use data, you're digital. You don't have to be a tech giant to be digital. So I'm curious, how many people here are aware of this call out by the Bureau for commentary? Okay, not that many. It's very interesting, because I had a discussion with the Bureau about why they did this. This is very unusual. It's like you're beating the bushes, trying to find out about who's doing things that, people don't like. It's a bit strange, but I was talking to a senior Bureau person, and she said that a lot of companies don't know that they can complain to the Competition Bureau, and that's why they issued this call out. So interesting that they're not actually reaching people, and because I would expect you would have above average exposure to this sort of press release. So it's indicative that perhaps the call out itself wasn't successful. So it is unusual. for the Bureau to actively seek complaints, but it fits in with their strategy of looking for issues in the digital economy. They specifically talked about in the call-out, sort of the pages that went with the call-out, online search, display advertising, social media, and online marketplaces. So I'm not going to spend too much time on this, but you might say, well, why focus on the digital economy? There's a lot of talk about, is this just old wine in new bottles? Do we need a new competition enforcement tools? And so far the answer seems to be, well, we might be okay. I think we may have enough tools, but we might have to look at things a little bit differently. So the Bureau has reiterated that big doesn't mean bad. So if you're a company that has market power, that does not mean that in itself is not an offense. It doesn't violate the Competition Act. But the concern is about winner-take-all markets. And those can arise in the digital marketplace, and for a couple of reasons, which network effects is one. So network effects are where you have a market where the more users there are, like a social media platform, the more users you've got, the better the system works. Or the more users you've got on Facebook, the more advertisers you're going to have, because they complement each other. You want to be part of a platform that gives you access to a lot, as an advertiser, to a lot of users on the other side. Large volumes of data can be a competitive advantage if your product requires, for example, machine learning. The more data you have, the better your product will be. There may be significant economies of scale or scope because there are high costs of developing the product. So those are the sort of the issues that the Bureau has looked at and that result in winner-takes-all markets. That's why you end up having very large and successful tech companies. So one of the issues that the Bureau identified in its call-out on the digital economy was, it called it creeping acquisitions. It's also called killer acquisitions. And that's where a company pursues an acquisition strategy involving the buying up of future competitors. So that may be, startups, for example. And you'd say, well, how is that negatively affecting competition? The concern there is, I think I might have. The concern there is the prevention of competition. So if you buy up a startup, then you're potentially preventing the emergence of a real threat to your own position, position in the market. So you may buy that startup you may bring it into the fold in your own company, or in some instances, there has been evidence, not in Canada, but that you've got one of these acquisitions occurring, you shut down the company that you buy in order to prevent the new type of competition in the market. These type of cases, you think, okay, well, so what would the Bureau actually have to prove? They'd have to show that it would cause a substantial prevention of competition. In order to do that, the only way you can do that is you'd have to forecast that startup would actually have succeeded. And that's difficult to know. When Facebook bought spent $715 million buying Instagram in 2012. Instagram had only 13 employees and zero revenue. So it's easy to say after the fact that that was potentially a prevention of competition, but harder to tell ahead of time. And back in 2012, it would have been very difficult to know. The other issue is that a lot of, if you're a startup, you want to be bought up. In a lot of cases, it's your exit strategy. So $715 million, that's the payback for you going in and starting the business up in the first place. So one of the things that the Bureau has done in order that it can identify this type of acquisitions, they've expanded the mandate of their merger notification unit to include intelligence gathering. And this Toma Bravo case is an example of the type of acquisition. We thought actually it was not notifiable, but we found out after the fact, the market found out, that this was actually a notifiable deal. But it's an example of the type of deal that the Bureau may look at. It involved data reserve software in the oil and gas industry. It involved a merger to monopoly. According to the Bureau, foreign competition was not significant enough, so the Bureau went after this. So this is a case, they're going, it's indicative of their focus on the digital economy, reserve software being very important, a very important input for oil and gas companies, production companies, figuring out, how much they're going to produce. Also for compliance with regulatory requirements, they need this software. So I'm not going to spend any further time because I see that time is fleeting. So I thought I'd spend just a little bit of time talking about the different types of conduct that the Bureau may look at as anti-competitive. And before I get into talking about some of the 4 boxes here, I wanted to mention that one of the provisions that the Bureau will use, there are a few provisions that the Bureau can look at. One is abuse of dominance. So that would be focused on a firm with significant market power. There are also other provisions such as there's a refusal to deal provision. It's a reviewable practice, and that could be implicated in dealing with, for example, access to data cases. If we're talking about abuse of dominance, one of the very interesting developments over the last couple of years has been that the Bureau has actually gone after sort of gatekeepers. So in the TREB case, the Toronto Real Estate Board case, the Bureau pursued as dominant the Toronto Real Estate Board. Well, the Toronto Real Estate Board does not compete in residential real estate. It is a board of different real estate brokers, and it's a self-regulating body. It has it issues rules that member brokers have to abide by. But the Bureau has gone after TREB, and successfully, in relation to their restrictions on certain innovative brokers who wanted to bring in who had virtual office websites and wanted access to sales prices in the for property listings. And so TREB went after not an entity that was competing, or sorry, the Bureau went after an entity that was not actually competing in residential real estate. In the Vancouver Airport Authority, the same thing happened. The Bureau went after an airport authority for limiting the number of in-flight caterers to 2. Again, normally, the Competition Bureau, you would think that they're focused on how a dominant firm acts in relation to its competitors. But we've seen these 2 cases where the Bureau is actually going after the gatekeeper. And that is probably, well, I'm aware that the Bureau is looking at that as kind of a precedent to going after digital platforms where the platform itself may not compete in the downstream market. So I'm going to now talk about the 4 examples, and I'll probably zero in on the refusals to supply data because we've actually got some cases there. But self-preferencing is where you've got a firm that prefers its own products and services. So it's a platform that's selling, and it's, if you think of it in the analog example, you'd have a store putting private label products, on the preferential, the preferred shelf space, so at the end of the aisle. So self-preferencing, it's not something new, but this is something that the Bureau has identified that it will look at. Most favored nation requirements, there have been cases in the EU dealing with this. So this is where you prohibit your suppliers from providing rivals with better prices or terms. And they did go after this type of behavior on hotel booking websites in Europe. Refusals to supply. This is an area where we actually have had some Competition Bureau enforcement in Canada. So I've already talked about the TREB case. So that was an instance where the Bureau felt that the TREB rules were preventing the emergence of these innovative brokers who wanted to have a feed of data from TREB that onto their virtual offices. It was interesting that the data was actually available by email, fax, so brokers could actually send the data to their clients, but TREB said they would not provide a data feed to these virtual office websites. This went on over several years, but ultimately the Bureau prevailed and TREB has had to change its rules. Another instance where data has been looked at is by the Competition Bureau. In 2016, the Bureau investigated whether contractual restrictions imposed by TMX Group on investment dealers and those restrictions prevented those dealers from sharing private market data with third parties without TMX's written consent. And the Bureau investigated whether that was an anti-competitive act. And in that situation, Equitas complained to the Bureau that it was seeking access to that data. That restriction prevented access, and the Equitas was seeking some relief from the Bureau. The Bureau concluded that it was sufficient future competition from Equitas's new product was unlikely to materialize in any event, so they discontinued the investigation. So you can see that the Bureau is doing some balancing. It's not a knee-jerk, everyone who wants access to something is entitled to it, because obviously you've got to be concerned about initial investments. If you have rules that say whatever you develop or a competitive advantage that you might have can be taken away, that you have to give everything to your competitors, the Bureau is not going to look at it that simplistically. They will be doing an analysis as to whether there is a real and substantial negative impact on the market as a result. I'm going to skip market squeezing or margin squeezing, and I'm going to only touch upon this extremely shortly to give Margot sufficient time, and it also to take any questions from you. I'll mention Hipster antitrust. It's sort of a interesting phrase. It's you've probably heard about this, but this is the idea that competition law should include considerations such as inequality, democracy, ethical considerations. The competition law should be enforced. So, example, you'd review a merger and you'd say, well, what's the impact of that merger, not only on future prices, but also on income inequality? How is it going to affect employment? So this is considered quite radical from a competition or antitrust perspective. And I'd say that, Elizabeth Warren and she's the best known advocate of this type of position. But I would say generally the competition authorities in most countries do not think it's part of their mandate. Having said that, I understand that the French and German competition authorities or governments have said that they may want to introduce industrial policy considerations as part of their competition review. But having in Canada, I would say that the likelihood that there would be a public interest test included as part of a competition review is quite low. It's probably very low. There are lots of other sort of interesting things going on, such as personalized pricing issues that raise really interesting issues, but there apparently is not a lot of personalized pricing going on in the economy. And personalized pricing, by that I mean prices that are geared to individuals rather than if you happen to have certain characteristics and are as part of a group. So I'm going to leave it at there. If we will leave some time for questions at the end of the session. But Margot, I turn it over to you, and you can have my glasses.
Thank you very much, Sandy. So my name is Margot Patterson. I work at in the Ottawa office of Dentons Canada, and my practice does include advertising and marketing. It's generally a media and regulatory practice, and so I spent the first part of my career working on broadcasting issues, and then moved over to the firm where I started working more intently on matters of advertising and marketing, and certainly over the course of my career, the digital side has been growing, and I thought that without going into too much detail or going into the weeds too much, I'd provide a touch on some issues that I see and perhaps some takeaways and best practices that you can think about in your own practice. So to start out, I've got sort of an overview slide for you. Wanted to explain to you what I mean by competitive marketing. Competitive marketing is not is something that I just sort of coined for this presentation. The underlying themes that I want to deal with are those issues where marketing is comparative. Marketing is really attempting to distinguish your product and service from a competitor's. And that may include marketing with superiority claims, biggest, best, highest, fastest, etc. And then also using consumer ratings to draw attention to your brand, and motivation usually be towards your brand and away from others. Second, I want to talk a little bit about how legal standards have evolved in the digital marketplace. I gave a presentation around some of these themes a few years ago, and one of the things that I said at the time was that the law hasn't really changed, but your marketing has and is changing as it shifts over to digital platforms. I think that now the law is starting to catch up, and I'll talk a little bit about what I mean by that. I want to touch a little bit on the Competition Bureau side of enforcement, the regulator, and also Ad Standards Canada, which is the self-regulatory industry body, and what it's doing in this space. And finally, some best practices to work with your broader team. So again, in terms of what do I mean by competitive marketing, again, I think it means trying to grab attention in what I think is an increasingly noisy and busy digital marketplace. So in 2018 in Canada, that was the first time that digital marketing spend surpassed what people call the traditional ad spend for the first time. So it tipped over the 50% mark. And Canada's actually punching above its weight there because according to stats, the digital marketing spend on a global basis is, or at least was about 9 months ago, at around 40%. Canada has exceeded the 50% mark. And a lot of that is on mobile advertising. Mobile advertising alone is worth more than 1/3 of all ad spend. And so it's becoming a very significant space to try to make your voice heard. Again, in terms of noisy and busy space digitally, some examples some of you will be familiar with in terms of what your marketing teams are doing. There are a lot of different places to be, a lot of different things to do on different platforms and using different media. And that's moving very quickly, as you know. And it means a lot of things. It means that marketing teams have the benefit of being more creative. They also feel the push to be more competitive, and elbows are out. There's a bit of jostling going on, and I find that in my practice, I see more people coming to me for advice in terms of how far can we push, saying that we're better, our product is better, our service is better liked, and even to the point of dealing with some exchanges of letters, cease and desist, and some disputes. So there is definitely the fact that the regulator is taking notice of all of this. It's taking notice more of the digital space and what's going on. And I find that the regulators are putting more emphasis on cross-border activity and how to make sure that they are enforcing, not only enforcing, but just monitoring activity in different countries. And so we've got the 2019 remarks by the new Commissioner of Competition, Matthew Boswell. Our Deceptive Marketing Practices Directorate will continue to prioritize investigating misleading representations made online and collaboration on borderless digital conduct in keeping with the Bureau's digital economy focus. And so, as we'll see, the Competition Act contains criminal and civil prohibitions against materially false and misleading representations. And the Bureau has taken steps and put more of an emphasis on what that means in the digital marketplace. So as part of its education and outreach to industry and consumers, it started publishing its Deceptive Marketing Practices Digest in 2015. And in that first bulletin, it had a focus on online reviews. And the Bureau made a point of noting that astroturfing, which some of you may have heard of, astroturfing is a practice of well, it's basically fake grassroots is the nutshell version. It's really an emphasis on spreading the word about a product or service in a way that suggests that people are providing genuine reviews and comments about the product or service, but those may not always be genuine. And so the Bureau has made a point of noting that astroturfing is a problem that crosses borders and highlighted at the time its excellent working relationship with international partners, including the US Federal Trade Commission. And so, again, I keep saying in my practice, I keep increasingly seeing instances where marketing issues or marketing disputes for my clients started in another jurisdiction. They started in the US, they started in the UK, and they have come to Canada. And that could be because the complainant is taking action systematically across jurisdictions wherever the similar claim has been made about that it takes issue with. Or it could be that the regulator in Canada has seemingly been monitoring or sort of taking notice of enforcement activity that's happening in other countries and taking some, at least investigation and sometimes some enforcement action itself. So the Competition Bureau has really focused and promotes borderless solutions. What does that look like? Well, you've seen that the Bureau does talk about and put an emphasis on its relationship with the US FTC. It also participates increasingly in international fora. There is the OECD Committee on Consumer Policy, which is more of a policy organization, and more importantly, possibly, it also pays attention to, participates in the International Consumer Protection and Enforcement Network, or ICPEN, which is a global network of law enforcement organizations. One of their activities is their annual sweep, where a lot of their members, and it does have 60 members participating, that is 60 countries around the world participating in ICPEN, doing sweeps where the organizations will sit down and review the practices within their jurisdiction and monitor where people are falling short and where it sees that there is reason for concern and potential enforcement action. In 2018, the sweep was with respect to terms and conditions, that is consumer-facing terms and conditions on websites and apps, of course. And in 2016, it was with respect to online reviews and endorsements. And finally, there has been a significant change in the law with respect to Canada's anti-spam law, which entered into force in 2014. The Competition Bureau is part of that because it enforces the elements of CASL brought into its own legislation that permit it to target misleading sender information for texts and emails and in misleading content as well. So the area for the Bureau, there are a couple in the digital, there's more than a couple, but a couple that I want to focus on. One is online reviews, which can get very, very competitive very quickly. As I mentioned, the Bureau is focusing on astroturfing, and it's also, I've called it the ratings wars. It seems that you can't go on Google these days and mention a product without lots of stars showing up about people's star reviews of the product and service. Even if you haven't typed in the word reviews, you just want information about the product, Google assumes that you want to know which is the best and which is the one that people like best. So, and then there's also the element of performance claims. So superiority, best, fastest, highest, most, and that's where the advertiser is making those claims itself in its marketing. And so under the Competition Act, as you may be aware, there are prohibitions. It is both a civil and a criminal offense where a person, by any means, directly or indirectly, makes a representation to the public that is false or misleading in a material respect. And with respect to, and here's, I'm going to get a little bit into the weeds here. The Supreme Court has told us in some decisions that misleading doesn't mean whether, it doesn't refer to your intent. It doesn't refer to what you think you're saying. It's really all about what the consumer, what the viewer of your marketing is going to take away. And it's about the general impression that that consumer will have. So, and we know as well from the law that you are thinking about the average consumer. You're thinking about the person with average or even perhaps less than average intelligence, who may be in a hurry, what the takeaway is from the spot. And so that's really important to keep in mind when you're trying to distinguish your product from somebody else's. You really need to be truthful. You have to be careful about your disclosures. You have to be careful about not being too punchy in what you're saying about your product, or be punchy, but just explain what it is that you mean when you say that our product works better, our service delivers superior results. Make sure that you are in a position to explain what you mean. And the Competition Bureau notes frequently that, don't forget, nobody actually has to be misled by your marketing for there to be an offense. There don't even need to be consumer complaints. It's sufficient for there to be the potential for somebody to be misled. And so we've talked a little bit about online reviews. Here we've got the problem of astroturfing. I'm going to give you an example in a moment. And then the problem of using, increasingly I see this, using consumer reviews in marketing for a product or service, where you are using Google reviews or your own reviews on your own website, those star reviews saying, this was the best product ever, I'm sharing it with all my friends, I'll never buy anything else. And whether or not you are focusing only on the 5 stars, whether you are, whether there's any astroturfing going on, whether these are genuine reviews, whether the number of reviews that you're talking about is accurate, it can get pretty competitive and pretty nuanced pretty quickly. With respect to performance complaints, performance claims, the Competition Act also makes it a civil offense to make a representation to the public in the form of a statement or a warranty or a representation about performance, the efficacy, the length of life of a product that is not based on an adequate or proper test. And again, you need to support what you say. So the Competition Bureau's one-liner is, don't make a performance claim unless you can prove it, even if you think it's accurate. And we know from Ontario courts that where a claim or representation is made about a product, the courts have said it must be substantiated by a very high standard of testing and expert proof. It really depends on the claim, what type of support how much support you're going to need, the type of support you're going to need. It's very case by case, but you do need to be in a position to get behind what you're saying. So what are the guardrails? As I mentioned, disclosures are very important. I won't really speak to this slide in any detail, just want to remind you that when you're making claims in a digital space, just because the screen is tiny, that doesn't mean that you can get away with burying the information or the support or the background or what else the consumer needs to know about the product somewhere else. It's a highly competitive market in digital. It's a noisy market, as we've discussed. People have a limited attention span, and the regulator knows that, and courts have recognized that. And again, there's small real estate to be considered. So won't speak to this in a lot of detail, but really we do provide advice from time to time on whether the consumer takeaway, because really often it's just this for maybe 2 seconds of a consumer's attention, whether that's going to be sufficient to tell the consumer the truth about the product and service that you're putting forward. So a couple of examples. One is the Bell Canada case that was back in 2015. So a year before that, in 2014, the Bureau warned consumers, don't buy into fake online endorsements, and provided some background around that issue. And then in 2015, seemingly to say, and we really meant it, It entered into a consent agreement with Bell Canada addressing what it perceived to be employee-generated reviews. It seemed like the employees were getting a little bit too enthusiastic. Were actually placing some of their own reviews about products about Bell apps on the iTunes App Store and the Google Play Store. So even though Bell reportedly moved very quickly to address the issues, take down the ratings, make sure that their employees knew that this was not part of Bell policy, the Competition Bureau seemingly took the position that it was too little, too late, or that otherwise stated that the damage was already done. As the Bureau said, these reviews and ratings created the general impression that they were made by independent and impartial consumers and temporarily affected the overall star rating for the apps. And so the administrative monetary penalty that Bell paid was $1.25 million, and it also committed to enhanced training and sessions to promote Canada's trust in the digital economy. The second example was fairly recent. It was only 3 weeks ago that the Competition Bureau entered into a temporary consent agreement with FlightHub, prohibiting it from engaging in misleading marketing practices on the websites flighthub.com and justfly.com. And the Bureau in this case received what it says were thousands of consumer complaints on these sites. The complaints had to do apparently with misleading representations about fares, seat selection, and flight rebooking or cancellation. And the Bureau also took the step of executing search warrants and seizing records from the company headquarters. When the consent agreement was posted on the Competition Bureau's website, Commissioner Boswell stated, "Early in my term as Commissioner of Competition, I made a commitment that the Bureau would use all the tools at its disposal to address deceptive marketing practices in the online marketplace, and today's agreement protects consumers from harm while the Bureau carries out its investigation." And just as I was mentioning earlier, often these disputes or events start in one jurisdiction and end up in Canada. This came 2 months after the state of California brought a lawsuit against FlightHub and JustFly over similar types of complaints. And so it's more important than ever, in my opinion, to keep track of what's going on in other countries. So just a couple of notes about Ad Standards Canada. Ad Standards is the self-regulatory body where it has a code of advertising standards in Canada that it has similar requirements to the Competition Act's requirements for avoiding misleading and false advertising. It has a couple of clauses that the code does about disputes between competitors. It does have a clause specifically stating that advertising must not unfairly discredit, disparage, or attack one or more products, services, advertisements, companies, or entities, or exaggerate the nature and importance of competitive differences. And so that provision is designed to allow the industry to self-regulate. And not only that, but Ad Standards has given a forum for a number of years to advertisers to bring their disputes to it. And the new procedure, which is less than a year old now, is streamlined. The fees are a little bit lower than, or in some cases fairly meaningfully lower than they were to bring a dispute before Ad Standards. The dispute process is faster. It's targeted to between 34 and 37 days from start to finish, and it can lead to a decision that can be made public, either anonymized or will name and shame the advertiser if the complaint is upheld, and if the advertiser whose advertising was found to be offside has not taken the appropriate steps, has not modified or taken down its advertising. And so disputes are before Ad Standards Canada are increasing I think not only because the digital space is becoming more competitive, but also because Ad Standards has made sure that it is an appropriate forum for people to bring their disputes for a fast and industry-led resolution. So just a couple of comments to finish in terms of best practices. When we provide advice to you around advertising marketing, we know that it's not just you that we're speaking to. We know that you are part of a broader team. The team includes you as in-house legal, it includes your marketing team, it includes the agency, can include your external legal counsel, it can include partners and sponsors that you're working with. And so we try to make sure that we bring practical advice to you that you're going to be able to immediately apply to agreements that you have with your partners, that you're going to be able to immediately share with your colleagues so that they are in the loop in terms of unrolling the concept and the program. We consider not only legal risk, but business risk, because we know that that's what you do as well. We consider how far you want to push the envelope, keeping in mind that in advertising and marketing law, things are always shades of gray. So often we will work with clients and give them risk levels in terms of green, it's almost never green, yellow, or red, just so that people can understand quickly whether they are taking on risk that is appropriate for their organization. In terms of best practices, obviously attending conferences like this one to keep up to speed, asking your external counsel to give you training sessions that include your colleagues so that you're not the only one harping on about these issues. Thinking about terms of timing, making sure that you are reviewing together with counsel as appropriate the program both at the beginning, but also as it is unfolded in the market, because often marketing is creative. It's very, it moves quickly, and sometimes it veers in unexpected directions. And finally, I would say that it's very helpful to consider templates that can be used again and again for similar situations. You can use templates and have your external counsel assist you to develop templates for contest rules, for agreements with partners, for licensing agreements, and for user waivers. And those can make sure that the advice is consistently followed, and can even be a good negotiating tool if you're in a position to say to your partner, these are our standard terms. We really do believe that these are important, so these should govern. So I will wrap it up there in the interest of leaving a moment or two for questions. Thanks very much for the opportunity to speak to you.